Welcome to the Deep Dive. Today we're looking at something fascinating in high-profile cases, that tension between a fair trial and, well, the public's right to know.
Exactly. And we're zeroing in on the Bryan C. Kohberger case, specifically this non-dissemination order, often called a gag order.
Right, and the big news is the media pushing to get it lifted. It's all about how things changed dramatically.
Yeah, our focus for this deep dive comes straight from recent court documents filed July 3rd, 2025. We've got a declaration from Wendy J. Olson and this key memorandum from the media.
Okay, so our mission here is to unpack why the order was there in the first place, what huge event changed the situation, and why the media is now fighting it.
Precisely. We want to understand that whole sequence.
So let's set the scene quickly. The Kohberger case involving the tragic murders of 4 University of Idaho students and a burglary charge, it got, well, massive attention right from the start.
Widespread publicity and worldwide media attention are the phrases used. I mean, it was everywhere.
And because of that intense spotlight, the court acted early, didn't it? There was this order.
Yes, the revised amended non-dissemination order dated June 23, 2023. Its goal was to limit out-of-court statements.
But it wasn't silencing the press directly, right? That's a key point.
Absolutely key. It specifically targeted the lawyers, prosecution, defense, attorneys for witnesses, or victims' families and their agents, like law enforcement, not the media itself.
So the court's main reason was protecting Kohberger's Sixth Amendment right, a fair trial, impartial jury, especially with all the media coverage described as rampant and ongoing.
Exactly. Protecting the jury pool from potentially prejudicial pretrial publicity was paramount.
How did the court justify restricting the lawyer's speech, though? Because lawyers have rights too, but the court saw them differently.
Right. The court pointed out that attorneys are officers of the court. They have this special duty, fiduciary responsibility, and unique access to information.
So they could be held to a different standard than the press.
A less demanding standard was the term used. The court essentially said the media's right was to observe and report on the proceedings, sit, listen, watch, and report, not necessarily to demand interviews from those involved directly.
Okay, that makes sense in the context of preserving a jury trial. But then the ground shifted completely. July 2nd, 2025. What happened?
That was the game changer. Bryan C. Kohberger pled guilty to everything, the murders, the burglary.
Wow, so no trial.
No jury trial for guilt, no jury trial for the death penalty. He waived his right to appeal. Sentencing will be up to the court alone.
Which means the entire reason for that non-dissemination order
is basically gone, moot.
The need to protect an impartial jury from pretrial publicity just evaporated with that guilty plea.
So logically, the media would then say, okay, time to lift the order.
Immediately. On July 3rd, the very next day, this coalition of 24 media organizations filed their motion to vacate the order. We're talking big names: ABC News, AP, CNN, FOX, New York Times.
And their argument is straightforward. Crystal clear. Kohberger's plea makes the original justification, fair trial preservation, moot. The restriction is no longer needed.
They also argue it's now actively harmful, right? That it impermissibly prohibits free speech.
Yes, they call it plainly overbroad now. They argue it strips journalists of a crucial tool, the ability to seek comment, provide context, hold power accountable, do their jobs effectively.
Makes sense. If you can't talk to the key players, reporting gets much harder. What did the state say in response? Did they agree it was moot?
Interestingly, no. The state actually opposed lifting the order, their reasoning. It would be easier for the parties in preparing for sentencing.
Easier? That sounds weak compared to First Amendment arguments.
That's exactly how the media coalition framed it in their rebuttal. They stated outright that attorney convenience is not a legitimate government interest strong enough to justify infringing on First Amendment rights.
So it really highlights the shift. The original strong justification is gone, replaced by administrative ease.
Pretty much. And the media is forcefully arguing that's not nearly enough to keep the restrictions in place.
Which brings us back to that core tension: fair trial rights versus free press and public information. It seems the balance point has dramatically shifted here because of the plea.
Undeniably, the whole foundation changed.
So it leaves us, and you listening, with a really interesting question to ponder. With a guilty plea fundamentally altering the landscape like this, what does this case signal about media access and the flow of information in our justice system, even after the prospect of a jury trial disappears? Something to think about.